Welcome to the North Carolina Court of Appeals. We have one case on for oral argument in the afternoon session. It is Carlson versus J.E. Dunn Construction Company and others. I'm joined on the bench today with my colleagues, Judge Flood to my right, Judge Julie Flood, and to my left, Judge Michael Stiding. I'm Judge Jeff Carpenter. I will be the head of panel today. We have Tom Salou as our marshal and Eddie Sampson doing yeoman's work as our clerk. Thank you, Eddie. Are the parties ready to proceed? Yes, Your Honor. Okay. We'll hear from the appellant.
May it please the court, my name is Kevin Rust. I represent the plaintiffs, the appellant in this matter. At this time, I'd like to reserve 5 minutes for rebuttal. Seated with me, although he'll be standing for part of the time, is Mr. Craig Allman, will be assisting me with some of the visual aids that we bought. Ms. Jen Reynolds, our paralegals in the second row, and Ms. Paula Carlson, one of my clients, is here as well. This case arises on the date of February 16th, 2020. The plaintiffs were in uptown Charlotte, Mecklenburg County, attending the Tony Bennett concert. It was a date that Mr. Carlson, a gift Mr. Carlson had gotten Mrs. Carlson to go see the concert. They had rented a hotel that night. They were going to have dinner and drinks and the like, and so wanted to be safe and walk, and so that there was no driving home, so they rented a hotel. This is the exact sort of behavior and conduct that the city of Charlotte would encourage, right? They want people to go out, spend some money, frequent their bars, frequent their restaurants, and do that sort of thing, which is why the city of Charlotte also requires contractors that are working within the city to comply with the watch manual. In this particular case, the defendants, there's two defendants. There's Johnson Bros, who is constructing the light rail car in the area of, for this particular case, the light rail car was going throughout city, but for our context, we're concerned about Trade Street. And some light rail activities were happening in and around Trade Street. At the same time, J.E. Dunn, referred to as Dunn, was building a Grand Bohemian Hotel, a Marriott property at Trade and Poplar Street, essentially in that general vicinity. And so there was construction going on in that area, and both those entities were required to comply with the watch manual. Homo on, please. This is, when it comes up for us here. There we go. Use permit, and I'll try to stand here by the mic. So this is the Grand Bohemian Hotel here. Poplar Street is about right here. This is Trade Street coming down. This use permit was issued from the city of Charlotte to J.E. Dunn to allow J.E. Dunn to close this section of sidewalk. There's a little black windscreen, a bit difficult to see, but this is sidewalk right here, and it allowed J.E. Dunn to close the sidewalk. And you'll note a couple important things. So the use permit here says at the very front, you must comply with diagram 1 of the watch manual. This is a blow-up of diagram 1 of the watch manual. Might be difficult to see even though it's blown up, but it requires that there be sidewalk closed signs to guide pedestrians where to go. And if a sidewalk is closed, it must say cross here or sidewalk open this way. Essentially, traffic signals or traffic directions for a pedestrian, in effect. And so on this right-of-way use permit, this is about 6 weeks before the injury. It was issued January 1, 2020. They're required to comply with this watch diagram 1. It also says to Dunn, please make sure you maintain pedestrian access and coordinate with the streetcar team, which is the other defendant, Johnson Bros. And it makes reference to Tim Morrison, who's with the city, to ensure pedestrian access. And so then on a third occasion, it says, Dunn, make sure that you have the proper traffic control devices and signage up as well. So 6 weeks before the injury, J.E. Dunn is told by the city, look, you can close this sidewalk over there, but you better make sure there's pedestrian access. And the testimony from Dunn was, we don't know if there were any signs up there, and we certainly can't see any sidewalk closed signs. Instead, they said it was their habit not to indicate where a sidewalk was open. If the sidewalk was open, it was open, is what they said. So on February 16th, the Carlsons are walking home from Midnight Diner post-concert and find themselves at the corner of Trade and Poplar, which is right about there, a bit further than when I practice, apologies. And right there, the Carlsons are standing right there, and they look ahead across the street over here, and there's a sawhorse with a sign up that says sidewalk closed. Mrs. Carlson testifies, well, we can't go that way. Carlsons are both ex-law enforcement officers. They understand how to read signs. They saw that the sidewalk across the street was closed. Johnson Bros attached a picture of that sign to their affidavit in support of summary judgment and just said, well, that wasn't our sign. Certainly the Carlsons would have no way to know if that sign was there correctly or otherwise. So on the night, February 16th, around 11 p.m., they're standing at this corner, staring across the street at a sidewalk closed sign. The testimony is also that across the street, there's a church here, and then across the street there's also construction near the gutter and that sort of area, and debris and the like. So they see a sidewalk closed sign, and immediately in front of them, up into that screen netting there, that sidewalk is open. There's a Morton Steakhouse there, and there's no indication, again, of a sidewalk closed ahead, anything like that. They get to that screen netting. It's not a type 3 barricade that you see referenced in diagram 1. This is a mesh netting to conceal construction debris and construction equipment, that sort of thing. And so the Carlsons are at this point near the mesh netting and look to their left and testify there's an open passageway. And this is the open passageway right here. This is otherwise Trade Street that's closed for the construction. Now, at the summary judgment argument and in briefing to this court, the defendants took the position that the Carlsons had to squeeze through this narrow opening to get into this open passageway. That's not the testimony. That's a jury argument. The testimony is Mr. Carlson said there was an open passageway, so we took it. And indeed, in the months and even the hours preceding the accident, well, dozens didn't use this passage in the hours before the accident, but dozens of people in the months leading up to the injury used this as a pedestrian walkway. In fact, on at least 2 occasions, there was a car driving up and down this access point. Dunn testified that this area was supposed to be closed off from the public. Dunn testified that although they had these pictures taken, this is a Dunn picture, that they did not apparently routinely view them to determine if pedestrians were accessing the site. But pedestrians were accessing the site regularly because it was an open passageway. As the Carlsons make their way down this area here, they eventually encounter some construction equipment. Now, their ultimate goal is to get to this next intersection over, where they can catch on to a sidewalk and make the rest of the way to the Aloft Hotel. So as the Carlsons encountered this construction equipment, they testified, it made sense to step out into the street. We had a very short distance to go, and there wasn't a lot of traffic. They testified they were keeping a proper lookout for traffic as they walked down the street. As Mr. Carlson is walking down the street, and Craig, if you could flip the second one, please, I'd appreciate it. As Mr. Carlson is walking down the street, he feels something hook or catch his leg, which propels him forward. Here at this area right here is where there's a fence that has been removed and laid flat. Dunn itself acknowledged it would have been nice to have that fence post behind the Jersey barrier. The plaintiff's expert testified that it served no construction purpose. Obviously, it's an unused temporary construction fence that was laying flat. There was a cone partially in front of it. Craig, come on, remove it a second as well. This one here. Thank you. Sorry, one more. I'm sorry, get the second one there. I'm sorry. Just move that one over for me. Thank you. So here was the laying flat. Now this picture is taken 2 days after the injury. The testimony was that the metal fence post was actually jutting out slightly beyond that orange cone further than it was here in this picture. That's from Mrs. Carlson. And so the cone actually operated to conceal the hazard because the cone was partially, or excuse me, the fence post protruded partially out beyond the cone. And so in the briefing, though, the defendant said, taking inferences in their own favor at summary judgment, that Mr. Carlson had to somehow fall over the cone. Well, that's not true. Mr. Carlson could have walked just alongside of that cone and still caught the fence post. And so it's on these facts in which Dunn admitted by their own admission did not comply at all with their obligations under the use permit, which required them to comply with the watch diagram whatsoever. There was no signage indicating where the Carlson should go that night. And in fact, the only signage that they saw indicated that the sidewalk across the street, which the defendants will argue was open, had a sidewalk closed sign in front of it. Now, maybe the sidewalk was open, but that's a question: would a reasonable person have walked across the street in light of the fact that there was a sidewalk closed sign across the street? And so that's one of the issues that we're dealing with. And it's important, in some of the briefing that has been submitted both to the trial court and to this court from the defendants, it's an impression that, you can flip those both around, there's an impression given that this is some really active construction site and the Carlsons are climbing and crawling over construction debris and equipment. That's simply not true. The photos bear this out. Pedestrians were using this all the time. Thanks. And so there's a reason why the city requires this watch man. If you'll put that back up, thanks. And it's to protect pedestrians. This would essentially be like if a construction company went and removed a stop sign and didn't put anything back up and blamed the motorist for getting in an accident. These are pedestrian walkway signs that weren't in place for the Carlsons to make an informed decision about where to go that night. Now, there's been some talk about Poplar Street being open, and I will admit in briefing I was a bit confused when they argued that Mr. Carlson testified that the sidewalk on Poplar Street across the street was open. I had thought that they were talking about the sidewalk across the street that had the sidewalk closed sign. As the court can see, though, this is from Phil's deposition. This is Poplar Street that I've highlighted. The highlighting is mine. This is the the Marriott where the injury occurred, and this was their destination. The defendants have not come forward with any evidence whatsoever of an actual alternative route, known or unknown, to the plaintiffs that night. The reason they can't is because there was supposed to be the signage up that directed the plaintiffs where to go, and they just didn't comply with it. The case law, Your Honor, in terms of walking in and around construction site and walking in and around the road is pretty clear, and it's not contrib as a matter of law. Now, could a jury ultimately on these facts determine that the Carlsons were contributory negligent? Sure, that could absolutely happen. But there is not evidence that this was contributory negligence as a matter of law, particularly in light of the fact that the Carlsons had no information that they were entitled to have under the watch manual. Both Johnson Bros and Dunn were required to comply with the watch manual, and neither did. Had the proper signage been up, and apparently the improper sidewalk closed sign been down, we're not standing here because Mr. Carlson would have gotten injured.
Counselor, we received additional authority from the defendants, from Cullen.
Yes.
And I would like for you to help me understand why this does not fit very closely with Cullen as to the open and notorious. I've heard you discuss fencing. I've heard you discuss cones, barriers. By your client's own admission, they could have taken a more circuitous route to find an open sidewalk, so they were aware that they could go a different way. But in fact still stepped around many of these things, despite any negligence that may or may not have been on the defendant's part. Help me to distinguish Cullen here then, if we are not bound by that.
Sure, I think fundamentally Cullen, I wrestled with citing Cullen coming up here on the second round, and the reason I didn't, the facts are not the same. This was an individual that fell in her own home. I mean, you can have a contrib problem out of the chute there. She acknowledged that if you step in insulation in an attic, you're going to go through the ceiling. I think that's fairly common knowledge that if you're not looking where you're walking in an attic and you touch insulation, there's a pretty good chance that ceiling's not going to hold you. And so in that particular case, it's really important to look down where you're walking because the insulation is the greatest risk. Whereas here, the unfortunate thing about this cone, they would have been better off without the cone probably, but the cone actually caused the fence post to be concealed. And so I'm making this sort of motion about like a fist length, I'm not sure exactly what it was, that was partially sticking out. Had the cone been all the way out, maybe we're not here today. And so in Cullen, there was this talk of this scuttle hole, that there was an additional attic access in the bathroom that they had, I think, drywalled over so that it looked nice in the bathroom. But ultimately, reading through the court's decision, the bottom line here is she knew that if she stepped in insulation in the attic, she was going to go through that ceiling, that there was risk involved with that happening. So I'm not even sure how important the scuttle hole was to her injuries in that case. But regardless, she was aware that you're in an attic and this is the risk you need to be looking out for. Whereas the Carlsons had a very short distance to go to get to the intersection. They were not aware of an alternative route. I mean, certainly there are any number of routes anybody could take. I could have, not to be too coy, but I could have driven through Charlotte from Greensboro to get here. Not a particularly smart route, not a reasonable route, but would it have been reasonable for the Carlsons to backtrack and walk up and down Poplar Street? That's a great question for the jury. I think under the circumstances, we will argue if we're fortunate enough to have the case remanded, that the Carlsons, having only a short distance to go with light traffic at the time, were acting reasonably given how close they were to their hotel. Certainly defendants will argue you should have gone backwards in a different direction from your hotel. The other important thing that I'll note about finding some alternate route. Mrs. Carlson testified there was construction all over the city that night. So it wasn't as though, because the record will indicate at these various points on this map, they were walking back and forth in and around the city, and so they were constantly confronted with construction. So it wasn't as though they just came from a pristine, newly constructed area, sidewalks, everything's perfect, everything's great. It was everywhere. And so under the circumstances, they felt this was a reasonably safe choice to take, and they made the decision to walk down the street. And interestingly, nothing about the street, being in the street, caused their injury. It was the failure to secure this construction debris that caused the injury.
So despite the factual differences, Cullen starts out with a pretty clear statement. The law expects individuals to take reasonable steps to protect themselves from open and obvious risks. Are you contending then that this was not open and obvious? I mean, is that the crux that you're getting to?
Well, that's precisely right, Your Honor. Because of the condition on the ground, it was not an open, the fence post protruding out was not open and obvious. It would not be reasonable, would be our argument to the jury, should we be fortunate enough to make that case, to expect of the hazards that you're dealing with on your day-to-day basis, whether you're on a sidewalk or somewhere else or driving your car, you're not expecting a fence post to have been removed and laid flat and sticking partially out in your way. And that's where the reasonableness comes in. Now, maybe a jury disagrees with me. That could absolutely happen. And we'll of course argue to the contrary, but so there's factual difference and there's also the open and obvious. And for me, insulation in an attic is so painfully obvious, of course, that the case I don't think has much value in terms of deciding how this court should rule today. To the contrary, though, the Broadway case, which is a Supreme Court decision as well, this case, as far as personal injury claims goes, is about as on point as we're going to get. In that particular case, in fact, I think the facts are worse in that case, but in the Broadway case, the plaintiff was walking towards a home, it was in Greensboro, and there was an 8-foot deep ditch in front of this home that spanned the distance of the home. And he's walking there, I believe it's at dusk, and someone says to him, "Be careful, there's a ditch there." And he says, "Yes, I've seen it," and laughs and makes it to the house. The plaintiff leaves the house at 10 p.m. later that night, full knowledge there's an 8-foot deep ditch there and construction activity. He doesn't bring a light, and he's feeling his way around in the dark in an effort to avoid the ditch. He bumps into 2 pipes, falls in the ditch, gets hurt, and the Supreme Court held this is not contributory negligence as a matter of law. The court actually distinguished in that case the Dunn case, which the defendants have relied on heavily. Dunn is interesting in that the plaintiff in that case, he was injured at a train depot. He'd been there several times during the day. He had actual knowledge of 2 routes. One was safe, one was riskier. At night, he chose the riskier route. That's not this case. The Carlsons weren't aware of an alternative route, and they weren't aware of it because they weren't told of the alternative route that Dunn and Johnson Bros should have told them. Cross here, sidewalk closed. And so that's why the actual negligence of the defense is so important in determining how the Carlsons acted that day and whether or not they acted reasonably, because we have to find them where they found themselves, which was with no signage that was supposed to be there. The Dunn case that was also relied on by Broadway involved an injury at a sidewalk. There was construction material, loose bricks, things of the like, and the plaintiff was dark and was feeling her way around with her feet. And the court held that it's our common understanding that people in the dark often feel themselves around in the dark with their feet. And the fact that she was injured, even though that construction site had been there for 2 months, was not contributory negligence as a matter of law. And so that's not terribly dissimilar from this case in that the plaintiffs were walking in and around or near a construction site when they got injured and were being safe, maintaining a lookout for traffic, which was the reasonably foreseeable risk at the time. There's a Lenz case that was actually initially cited by defendants from this court. Lenz was the trial court had granted directed verdict on contrib as a matter of law. The plaintiffs took an appeal. The plaintiff in that case was leaving his apartment during an ice storm, walking to his car. The plaintiff saw the ice, took the path, fell, and was hurt. He sued the landlord. The plaintiff acknowledged that there was an alternative pathway available, but that there was generally still ice in other places. The court determined that even though, if I may, just read the holding of Lenz, it was for the jury to decide whether in the exercise of reasonable care for his own safety, plaintiff was required to use a different route from the one he took on the occasion in question. So this is not terribly dissimilar, even though the plaintiff in Lenz mentioned, well, there was still ice in other places. This was more or less, if you replace ice with construction activities, the situation the plaintiffs found themselves in. There was construction everywhere. They had a short distance to go. This was the path they took. Now, is it possible a jury might decide that it wasn't the reasonable path? Sure, that is a possibility. That is absolutely a possibility. The Clark case is a North Carolina Supreme Court case that I think is also instructive. In that particular case, the plaintiff had a pathway in which they were walking that was blocked by a parked car. So plaintiff stepped off the pathway and entered into the roadway and stayed within, I believe they said, 12 inches of the curb. So basically hugging the curb, not too dissimilar from what the plaintiffs were doing here, and was still struck by a car. In that case, the court noted first there's a statute about where pedestrians should walk, and the court noted first that the statute does not, in violation of that statute, is not contributory negligence per se. And they said that given that the plaintiff was walking close to the curb and the evidence that was presented allowed for diverse inferences as to whether plaintiff acted in a reasonable manner and whether her acts proximately caused her injuries. And so this is what it comes down to. Did the plaintiffs act reasonably in this case? And you may hear an argument to the effect of they weren't they weren't looking where they were going. Well, we filed a memorandum of additional authority. It's a Food Line slip and fall case. It's for the jury to determine whether or not it's reasonable to walk looking down at your feet. I don't think that's what most people do. They don't usually walk looking down at the feet. Now, I would say in Cullen, she absolutely should have been looking down at her feet, given where she was at the time. In that Food Line case, she slipped on grapes. She didn't know for certain that grapes caused her fall, but after she fell, she saw that there were grapes on the bottom of her shoe and the like. And the court held that this is a jury question to determine whether or not it was reasonable for her to be looking at what she was shopping for, or whether or not she should be looking down at her feet. Now, again, a jury may ultimately decide that Phil and Paula should have been staring down at their feet under the circumstances. But that's a question that should be resolved by the jury, not a court. A couple other cases that I'd like to touch on that defendants relied on. There were two industrial commission cases that they relied on, Webb and Gottlieb. I will confess I was a little perplexed to see those cases reappear. The industrial commission was sitting as a fact finder, and they weighed the evidence. Actually, in Webb, made inferences against the plaintiff, which they're certainly permitted to do as a fact finder, and determined that it was contributory negligence as a matter of law. And so those cases have no applicability whatsoever. If we go back down and have a trial and the judge submits evidence on contributory negligence, maybe we're back here talking about Webb and Khatib, but those cases are simply not summary judgment cases. There's no determination as a matter of law. Likewise, defendants maintain that Smith v. Fiber controls, that the plaintiffs ignored this controlling authority. Smith was a jury trial. The issue of contrib as a matter of law was not before the court. Likewise, they rely on a Court of Appeals case in Lovett. In that particular case, the individual blew a .36, which is high, and jumped in a pond at a mall twice and drowned. The court's holding was expressly on the alcohol consumption on contrib. In this particular case, although there is evidence, testimony, that the Carlsons consumed alcohol over their day in Charlotte, there's no admissible evidence as to Mr. Carlson's blood alcohol content as we sit here today. So that case has absolutely no bearing whatsoever. If I could touch briefly on the gross negligence standard. First, if the contrib issue is reversed on the negligence, we don't need to get to the gross negligence argument. But generally speaking, gross negligence arrives when there's a willful failure to follow a contractual or legal duty. We've identified what the legal duty was here in terms of putting up signs, and additionally in briefing we referenced the building code, which requires that a pedestrian access be maintained, and also that construction debris is not left so haphazardly out. And so in this particular case, as I mentioned earlier, Dunn testified that it wasn't their habit to comply with this watch manual effectively, is what they said. And although the deposition occurred after summary judgment, Johnson Bros testified that they didn't care how materials were stored on the construction site. That was their statement. Craig, if you could pick up the bottom one briefly. There's one area why this is important in terms of storing the construction material. Mr. Carlson's injury initiated or commenced at this point when he had his foot hooked. He then stumbled forward, and you can see some additional construction debris that is just sitting out nearly in an intersection. This caused him to pitch forward as he stumbled over that a second time, which then led him over to an excavation that had not been filled in after construction site, and there was a lip on that excavation. So Mr. Carlson, former law enforcement, knows how to fall like so, doesn't put his arms straight out, puts his arms out like this to not break his wrists or elbows. And because of that lip, because of that excavation that wasn't filled in, he hit his forehead first, if not first, at least his forehead took the brunt of the impact and broke his neck, which rendered him with partial paralysis today still. He was able to regain function, a degree of function in all four appendages, but he did suffer a broken neck and incomplete spinal injury, as we talk about in more detail in the briefs. So This entire construction area, as the court can see, was sloppy. The items were not maintained as required under the building code, and the parties apparently didn't care to comply either with their obligations under watch. So it was really a double whammy that the Carlsons found themselves in. They first weren't directed to an appropriate sidewalk that would have been safe. And second, even if they found themselves where they found themselves, the construction site itself was not properly maintained. And so these risks of this fence post sticking out was neither open nor obvious. Mr. Carlson testified he didn't see it. And of course he didn't see it because a jury could reasonably infer from the facts that it was concealed so that a person walking down the street wouldn't see it, causing his injuries. So for these reasons, the trial court's grant of summary judgment was improper. There are issues of fact as to what sidewalks were open, and there are certainly factual issues as to what a reasonable person would have done under these circumstances. For those reasons, this court should reverse the trial court's grant of summary judgment.
Thank you. Hear from the appellee.
Thank you, May it please the court. I'm Stephen Cox from Robinson, Bradshaw, and Henson, and with me this afternoon is my partner, Hannah Crandall, representing the defendant, J.E. Dunn Construction Company, and also at counsel table with me is Mr. Stephen Bader, who represents our co-defendant, Johnson Brothers. I'd like to reserve 3 minutes in case Mr. Bader needs any time to clean up any issues at the end. Thank you very much. Mr. Rust reviewed a good many facts in his presentation, so I'd like to begin mine by just sort of refocusing our presentation this morning on the issues of law that really support the trial court's grant of summary judgment in this case. Negligence, the negligence of the defendants was not the basis of the summary judgment award, of course. That's presumed for purposes of this argument. The basis for the trial court's grant of summary judgment was that as a matter of law, the plaintiffs in this case were guilty of contributory negligence. And there are 2 issues in particular, 2 separate and independent issues that support the trial court's grant of summary judgment in this case. First is that a plaintiff who departs a pedestrian pathway, whether a sidewalk or a crosswalk, and crosses into a risky area to take a shortcut, bears that risk. And if that plaintiff is injured in the course of that shortcut, that plaintiff is contributory negligent as a matter of law. Those are the lessons, that's the lesson of the Webb case, in which a plaintiff left a sidewalk in a North Carolina rest area, crossed through some pine straw, and was injured when he tripped on some metal landscape edging. It's also the lesson of the Khatib case, in which a plaintiff was departed from a crosswalk, crossed over a grassy median, and fell into a storm drain. I understand Mr. Rust is attempting to distinguish those cases on the grounds that in Webb and Khatib, the facts were decided by a fact finder. In our case, we don't need the facts to be decided by a fact finder because the facts on which we're relying are undisputed. But regardless of how the facts are decided, whether by a fact finder or by undisputed facts, the important features of Webb and Khatib are the rule that they applied, the legal rule that they applied to both those sets of facts, is when a plaintiff takes a shortcut across an area that has a capacity for risk, the plaintiff bears the burden of that risky choice. And the second rule we would rely on is the rule cited by Judge Flood that comes from the Cullen case. A plaintiff who ignores an injury-causing condition that is open and obvious bears the burden of that and is guilty of contributory negligence. That's the lesson of the Cullen case that was decided by our Supreme Court just a few weeks ago. A side note here that makes Cullen particularly interesting in this case. This is the second time this case has been to this court. You may recall the first time the city of Charlotte was a party, and this court properly dismissed the appeal sua sponte because the summary judgment order was interlocutory. It went back down to the trial court, the plaintiffs dismissed the city, and it came back up again a second time. That's what's before the 3 of you this afternoon. At the time of the first appeal, this court had reversed the trial court's grant of summary judgment in Cullen. And plaintiffs made much of that in their first brief. They relied heavily on Cullen in their first brief that came to this court. By the time the case came back up a second time, the Supreme Court had granted cert in Cullen. And plaintiffs wisely decided not to cite at all in their second brief to this court a case that may have been overruled by the Supreme Court. I think I would have done the same thing. And the Supreme Court did just that. It reversed this court, reinstated summary judgment in Cullen, and that's the rule that applies here. The rule is that a plaintiff who ignores an open and obvious risk bears the burden of that choice. And I'll cite factual testimony in a moment, Judge Flood and members of the panel, which makes it very clear that that's exactly what happened in this case. So with these two principles of law in mind, let's review Carlson's conduct here. Mr. Clerk, if I may use this Elmo, if I'm lucky enough. And let's start by saying we remember, here's the context. The Cullens come to Charlotte on a Sunday afternoon in February. They're here to see the Tony Bennett concert. They have burgers and a beer and a drink at a local bar. They go back to their hotel and rest. Then they go to the concert, have a few more drinks, walk downtown to the Midnight Diner, for those of you familiar with Charlotte, where it used to be. And then they come back uptown to try to find the Crave dessert bar. Miss Carlson testified that she wanted to go to this dessert bar in town, but they couldn't find it. And so they end up at the corner of Poplar and Trade Street, which is right there. The corner of Poplar and Trade, where Mrs. Carlson consults her phone to try to find the route back to her hotel. I'm going to put another drawing up that makes this even clearer. I think this is a picture that Mr. Rust used in his presentation. Here's where they are at the time they come up the street. So I just put that X. They're at that corner at Trade and Poplar. And then they call up the instructions on their phone to go this way to their hotel, which is here. The alternate route, of course, is to go this way on the backside where the hotel is here. In any event, I think the testimony is now clear. There was some confusion in the initial plaintiff's briefs, but I think they now concede that although there's some discussion as to whether this road was blocked with a sidewalk closed sign, there is no debate, and it's conceded, that Poplar Street was open on both sides. In fact, Mr. Carlson admitted in his deposition they could have used the open sidewalks on Poplar Street. In fact, that's how they got there in the first place. So there they are at the corner of Poplar and Trade. They've got to get back to their hotel. They start heading down Trade Street. And now I'll put up this picture again. They head down Trade Street for just a little bit before they hit that black fence covered with a black construction netting. That orange circle around it is a circle drawn by Mr. Carlson during his deposition to show where they were. Now, why was the fence there? It was there because on that evening, at that time, the Carlsons were on the margin of two construction zones. My client was building the Grand Bohemian Hotel, which, as you can see from that picture, was almost done. And Mr. Bader's client was constructing the Charlotte streetcar line in the middle of Trade Street. So they get to this fence covered with this black netting, which had been erected by my client to prevent access to the construction site, and they had a choice. They had the same choice that the plaintiff in Webb had. They had the same choice that the plaintiff in Khatib had, whether to circle back to an open sidewalk and find another route to the hotel, or whether to cross into an area known to bear risk, a construction zone studded with white jersey barriers. You see those here, all along that chute, that sandy chute, construction cones, and down here even construction machinery. And like the plaintiff in Webb and like the plaintiff in Khatib, the plaintiffs made the riskier choice. They took a shortcut, they left the sidewalk, and they continued down that chute. As a side note, this photograph is dated 11:09 p.m. We think those figures in the chute are the Carlsons. That's disputed, but that's what you see there in the chute. They come down that chute, and as you see here, they soon encounter this construction machinery, which is part of this construction site. Again, they had a choice. They could have gone back by Mr. Carlson's own testimony and found an open sidewalk via a circuitous route. That's not the choice they made. They doubled down on their initial risky choice and adopted a second one, to cross into Trade Street itself. And then, after continuing down Trade Street a short time, Mr. Carlson tripped and fell. I asked him during his deposition, did you give thought to maybe crossing Poplar Street? Remember the route we looked at earlier? Crossing Poplar Street and going down that open sidewalk. And he said, no, it just didn't make sense. There wasn't a lot of traffic, and it was a short distance to go into the road and get to that next intersection. That's at the Rule 9D, Exhibit DE 414. In other words, the Carlsons made the choice that the plaintiff in Webb made and the plaintiff in Kantib made, a choice of convenience, not prudence. And as this court said in both of those cases, or excuse me, in the Webb case, prudence rather than convenience should have motivated the plaintiff's choice. That was the court's ruling in Webb. On that basis alone, summary judgment by the trial court was proper. They attempt to distinguish those cases on a number of grounds. Broadway, in which the plaintiff was not aware of any other route he could have gone around. Same thing in Darden. In the Lenz case, you may recall, that involved a college student in Greensboro who was in his apartment parking lot, and he tripped on some ice. He said there were alternative routes there too, but they were also icy, so there was no evidence of anywhere else he could go that was not dangerous. And for those reasons, as explained in our brief, those cases are readily distinguishable. But separately and independently, the second legal rule I started with bars Mr. Carlson's claim. And that is, they failed to heed an open and obvious risk. Let me start with this. In their petition or complaint to the court, in their brief to this court, the Carlsons asserted that Mr. Carlson tripped on a fence post. But in his deposition, that's not what he said. In his deposition, he said he didn't know what caused him to trip. Mrs. Carlson said the same thing. She didn't know what caused him to trip. After the ambulance came and was tending to her husband, Mrs. Carlson started surveying the area. This is all in the record. And she was looking around, and she saw the fence post, and she assumed that's what he tripped on. But there's no testimony in the record that someone saw that happen or knew that happened.
So would you guide this court to look at the openness and obviousness of the entire construction site and the cones and the fence and construction equipment, or would you guide us to look at the openness and obviousness of that fence post?
I would guide the court to look at the total context, right? Because what the court says in Webb and Kantib and all these cases, it's a reasonable person standard. It's an objective standard, not a subjective standard. So on the first rule that I cited about an alternative route, when a reasonable person is sitting at this corner of Poplar and Trade and they come to this netting, they have a choice to make. Do they walk out into an open construction area, or do they try to find a safer place? When 3 or 4 minutes later they have another choice to make. Do they walk out into the street, or do they go back and start? With respect to the particular fence post and the cone, that's a whole nother level of open and obvious risk. And Judge Flood, let me now cite the testimony I alluded to earlier. First of all, there's no dispute. Mr. Clerk, I'm going to put this back up again. I apologize not for telling you about it earlier. This is a picture that's in the record that the Carlson's son took a couple of days after the accident. Mrs. Carlson did testify, as Mr. Russ said, that she thought that metal post was sticking out more from the cone, but she admitted, this is clear in the record, she admitted that the cone was in front of the post. In other words, coming down from Poplar and Trade, this direction toward the cone is in front of the post. And I asked Mrs. Carlson during her deposition, I said, this cone would have been pretty visible walking along that Jersey barrier, would it not? She said, it would appear that way. I said, do you know why your husband would not have seen that cone? And she said, I can't answer that question. Mr. Carlson, for his part, testified that he never saw the cone. Let me show you one more picture that I think is instructive. This is a picture taken by Mrs. Carlson with her phone the night of the accident. In fact, she took it through the window of the ambulance. And you can see that this cone rises above the level of the Jersey barrier and is plainly visible. But that is not, I think, the most powerful and important testimony for the purposes of this case and for the purposes of supporting the trial court's judgment. The most important testimony, I think, is testimony on page 437 of the 9D supplement, in which Ms. Carlson volunteered this information. The concrete post and the metal was sticking out more into the roadway, which was visible if we had looked down. And I said, if you would have looked down, you would have seen it? And she said, yes, sir. That is virtually identical to the fact pattern in Cullen, in which the Supreme Court said this about this situation. In that case, the plaintiff was walking around in her attic when she fell through a scuttle hole that the contractor had left open. The trial court granted summary judgment. This course reversed. The Supreme Court granted cert and reinstated summary judgment. The plaintiff in that case, like the plaintiff in this case, argued that the risk was not open and obvious. The scuttle hole was not open and obvious. And here's what the Supreme Court said, quote, during her deposition, plaintiff admitted under oath that she would have seen the scuttle hole had she looked, close quote. Virtually identical to the testimony that Mrs. Carlson gave in this case. As the courts have said, a condition is open and obvious if it would be detected by any ordinarily intelligent person using his eyes in an ordinary manner. And for the reasons the Supreme Court held in Cullen, powerfully applicable to this case, the trial court's grant of summary judgment should be affirmed. Briefly on gross negligence, I think Cullen is very instructive on that issue as well, because in that case, you'll recall, the plaintiff was arguing that a violation of the building code in Cullen constituted gross negligence. That's almost exactly what the plaintiffs are arguing in this case. They've cited various violations of the watch manual and other rules of the city of Charlotte applicable to these defendants. What the Cullen court said, it affirmed earlier jurisprudence from this court. What the Cullen court said was mere violation of a building code does not constitute gross negligence. It may constitute negligence per se, but not gross negligence. You have to have some additional element of willfulness or wantonness to support a gross negligence verdict. And there's just no such evidence here. The plaintiffs have not cited any. If you review their brief, you'll see they're relying on is entirely a violation of the building code. We've been talking about the Carlsons collectively. Really, as I think plaintiffs concede, this is a case brought by Mr. Carlson. Mrs. Carlson does have a loss of consortium claim, but I don't think there's any dispute. Plaintiffs acknowledge that if Mr. Carlson's case fails because of his contributory negligence, her derivative loss of consortium claim must fail as well. So for all of those reasons, and especially because of the additional authority we supplied from the Supreme Court in Cullen, we would ask this court to affirm the trial court's grant of summary judgment.
Mr. Cox, before you go.
Yes, sir.
Judge Flood asked you a question in regards to openness and obviousness, the whole context, or as it relates to the end of the construction barrier post. Right. You said the whole context. So I was looking at your exhibit there, and it appears to me that the Carlsons were in the chute leading inside of the construction. Do we agree on that?
Yes, sir.
They're in the chute inside of the Jersey barriers created the chute, right?
Yes, sir.
They're inside of the chute. They encounter equipment at the end of the chute.
Correct.
And choose to step out into the road.
Correct.
Your position is that choosing to step out in the road was a more dangerous proposition than continuing backwards within the construction zone. Is that correct?
Yes, that's the second time they made a decision to extend further into a zone of danger and a zone of risk. And that really goes to the first rule of law I cited at the beginning, Judge Carpenter, which says that they should not have been in the Jersey suit to begin with because of the choice they made at first, but then again they doubled down on that. That relates to the first principle of law. You have to consider all the context. And then the second one, when you talk about ignoring open and obvious risks, there were a number of open and obvious risks throughout this construction site. The Jersey barriers are an indication of some, the construction machinery. I would say the final and most obvious open and obvious risk was this concrete post, which was visible if they had looked down, and was marked by a cone, which, as you see right here, is plainly visible walking along the roadway.
So the open and obvious risk, and I guess it's a question of what's reasonable under the circumstances, right? Is if it's open and obvious risk to enter into a construction zone. Well, they've done that.
Correct.
They're in the construction zone with no peril having occurred.
Right.
You would have them turn around and walk backwards within the construction zone.
I would have them turn.
Or take the more direct route to step out of the construction zone into the street.
Yes, sir, and here's why. Because remember, up to that point, they should not have been in that Jersey chute to begin with, right? Because it's a riskier area than staying on the sidewalk and reassessing. But they got in the chute, and fortunately for them, up to the point where they approached the construction machinery, they were fine. So the question is, okay, I've made it here safely. Now I have a choice as a reasonable person. Do I go back through a zone which I now know to be safe and get to an open sidewalk and reassess, or do I, a second time, flip the coin a second time and go now, not just in a construction zone, into the open street of Trade Street. I think you have to evaluate everything they did that night and everything they did during that brief period of time, from the time they left Poplar and Trade to the time they entered the construction zone, entered the street, and finally ignored that open and obvious risk of the post and the cone. Any one of those things we submit would support the trial court's grant of summary judgment in this case. Taken together, it's even 3 more reasons to do it. I hope I've answered your question.
Your colleague, you reserve some time. You've got plenty of time for your colleague if he wishes to be here.
Thank you.
Good afternoon, may it please the court. I'm Stephen Bader from Cranfield, Sumner, and Raleigh, here on behalf of Johnson Brothers. I would echo Mr. Cox's excellent advocacy and the points that he raised here today. I see there's plenty of time left, but unless the panel has any questions specific for me, I would rest on Mr. Cox's argument and ask the summary judgment be affirmed.
So, Mr. Bader, what we did was gave you the opportunity to speak, not the mandate. And if you choose not to, we'll respect that.
Very good. I will do that. Thank you, Your Honor.
So, Mr. Russ, you got 3 seconds left.
I'm sorry, Your Honor, I thought that the clock reset, or was going to allow me 5 minutes here. I didn't realize it was, I had to do my own math, so.
Started with 30. That's what the yellow light signified, was the 5 minutes.
Well,
Eddie programs that. But go ahead and tell us what you want to tell us.
if I just may have one brief minute, 2 things that stuck out: convenience, not prudence, and look at the total context. The party that chose convenience, not prudence, were the defendants who didn't comply with their obligations under the watch manual. And you must look at the total context, which includes the lack of signage directing the plaintiffs to where they're supposed to be. Apologize for running over to the court. We feel strongly that a lot of these arguments may be very persuasive closing arguments that I'll have to deal with, but there are questions for the jury about whether or not the Carlsons were reasonable that night. Thank you, Your Honor.
Questions, sir? Thank you, sir.
Thank you.
Thank you, counsel, for very good arguments. We will consider this case submitted, and Mr. Sampson, if you'll adjourn us.